Welcome. This is Brad Berkman, host of the Ardent Spirit. As you all know by now, or hopefully know by now, I am an alcohol beverage attorney at Green Spoon Martyr and part of the hospitality, alcohol, and leisure industry group. And we have this running podcast where we address all sorts of interesting issues. At least I find them to be interesting. Hopefully you do. Some of them deal with legal, regulatory, and compliance matters as it relates to alcohol beverage. Sometimes we just deal with industry stuff, like how wine is made or how spirits are made, and discuss or have conversations with industry members and industry participants, people who actually work in the field, not necessarily from a practitioner or legal practitioner's side, but from someone who's actually, out in the field, either making alcoholic beverages or selling alcoholic beverages or promoting alcoholic beverages. So we have a lot of fun, and hopefully you will find many of the topics as interesting as I do. Today, we're going to talk about something that I find kind of interesting from a variety of different perspectives, but let's set a little bit of the groundwork, right? So let's say that you want to introduce some sort of alcoholic beverage product, right? You have an idea for, I don't know, some sort of unique distilled spirits product. It's going to be the next hot item on the shelf or off the back bar. So how do you go about doing that, right? How do you go about creating an alcoholic beverage brand? And what are the costs involved, as an example? And what are the variety of procedures and processes necessary? So obviously, the starting point would be to actually qualify as a full-fledged manufacturer. And by now, I'm sure most of you realize a full-fledged manufacturer would be either a distillery, a brewery, or a winery. And in order to establish that, the costs involved are significant, more than significant. It's very, very costly to open up, as an example, a distillery. Just think about it for a second. The first thing you need to do is find yourself a plant, find yourself a warehouse, find yourself a space that you're going to, put all your equipment in. And of course, that goes right to the next part of the expensive part of the process. That is getting the equipment. You'll need, obviously, a still, and you'll need tanks, and you'll need pumps. But in order, in fact, before you even put those things in, you'll need to create the infrastructure within the building that supports those items and tools necessary and equipment necessary to produce distilled spirits. It takes a long time. There's tremendous, there's permitting processes, there are licensing processes, there's municipal approvals, state approvals, federal approvals involved. The resources required to set up a plant that manufactures distilled spirits are just sometimes prohibitive for someone that has a great idea in terms of introducing a particular brand. So what are the alternatives? I mean, if you don't have the money to invest in a distillery, what can you do? Wow, I have an idea. How about contract package? What's contract package, you may be asking? Well, a contract package arrangement is someone with a brand idea, someone that spent some time, developing a concept, perhaps trademarking a name, and maybe creating a formulation. That particular person or entity actually contracts with an already existing manufacturer, someone who has spent time in building out the premises I just described, the plant that I just described, and who has the expertise, a distiller as an example, who can help create a formula if necessary, and who can help or who will, in fact, distill the product into its finished form, and who can put it in a bottle and affix the labels and help you get that product to market. So, the contract packaging arrangement is interesting, right? It's a sort of a symbiotic relationship between the brand owner and the manufacturer. It helps them both. It helps both parties involved in the agreement. From a brand owner perspective, it allows the brand owner to spend money, resources on developing the product, and then developing and executing upon sort of the sales and marketing of that product. For the manufacturer, it's an additional stream of revenue, right? I mean, they have their own brands, hopefully, that they're producing and putting in the marketplace, but via contract, they are producing someone else's brand, and that other person is paying them to produce that particular product. So the relationship really works out well in most instances for both parties. Actually is a good source of revenue or an additional revenue stream for the manufacturer. And it can be a cost-effective way of launching a brand for a brand owner. Now, what's very important really in this type of relationship, of course, is the contract packaging agreement. And it's really important that the parties involved in the contract or in the relationship define the terms very, very clearly. The rights, duties, and obligations of the parties are clearly spelled out in the agreement. All the essential terms are discussed and worked out and memorialized prior to commencing the relationship. Some of the big issues that one would address in a contract packaging agreement would be things along the lines of, intellectual property rights to the brand. Who owns the IP? Who owns the trademark? And securing that and protecting that for the brand owner in the agreement. Some other things would include quantity, right? How much product does the brand owner want to buy or have to buy? How much quantity is the contract packager capable of, willing to produce? There's got to be a meeting of minds on that particular point, right? So I want to go out and sell 1 million cases of this great brand, and my contract packager only has the capacity to sell me 100,000 cases. Well, that's a foil to my business plan. That doesn't quite work. So it's very important that quantity terms are worked out and that the parties' expectations are met in that regard. Costs involved, production costs are also very, very important. Costs involved with raw materials, packaging materials, how those costs will be allocated, who will be paying for them. Payment terms clearly is an essential element in the agreement. How will the brand owner pay the contract packager at the time the contract packager or the manufacturer begins to produce? That's sort of just a little bit of a basic sort of survey of a few of the important terms. There are many, many, many other important terms that go into the agreement. But in order to have I think, beneficial contract package brand owner relationship, significant and well crafted contract packaging agreement has to be put in place between the parties. And so the parties clearly understand, again, the rights and obligations under the agreement, and going forward, ambiguity is really left to a minimum. Something just popped in my head. It's worth sort of talking about. Issues of recall, right? As an example, let's say we get bad product into the marketplace for whatever reason. Formula's off. Doesn't taste the way it should taste, or perhaps some sort of foreign object, as an example, made its way into the bottle. How are we going to deal with that? I don't know. We'll have to talk about that over time. Once we figure out how we're going to deal with that, we better memorialize that in the agreement, and we better know who's going to pay for any recall that may be necessary, the procedures and mechanisms for that recall. Always best to have these things worked out beforehand. If they're not worked out, you got it. There's going to be lawsuits, there's going to be problems, and it's going to be costly for all parties involved to try and solve the issues. Now, as part of the relationship, clearly there are other issues that would need to be addressed, appropriate licensing schemes. Both the brand owner would need to be appropriately licensed by the various regulatory authorities. Clearly, the manufacturer needs to be licensed by the appropriate regulatory authorities. These things are it's not quite perfunctory. We don't want to say that at all. They're not. But in terms of things that need to get done, well, they'll automatically go on the checklist of things to do because it's essential and must be done in order for the relationship to be compliant. So it's a pretty interesting relationship, I think. It's really productive, as I had mentioned, for a lot of different reasons. the interesting thing is, in these contract packaging relationships, both parties to the agreement are what we would call upper tier industry members. And you may have heard me mention that term before. So an upper tier industry member really qualifies, well, let's make it nice and simple. Virtually any industry member that's not a vendor, not a retailer of alcoholic beverages, at least for the purposes of this conversation, we can refer to as an upper tier industry member. And upper tier industry members usually are the brand owners, right? Either they are the actual producers of the product and they own the brand, or they are like the brand owner I just discussed, someone entering into a contract packaging arrangement with the producer, who is, brand owner and trademark holder and has all the, in essence, rights to the brand, but doesn't put in the labor, the manpower to actually create the product. So there's another interesting concept particularly in Florida beverage law, which we're going to talk about as well as part of this conversation, which you might find interesting. And it exists in a lot of other states with variations, but it's called basically private label. And a lot of times I find that people tend to use the term contract package and private label interchangeably, but in fact, they're really very, very different things. I think I've described fairly adequately what a contract package brand is. What's a private label? Private label on Florida law. So, when you're having an informal conversation, certainly you can interchange the two terms, but we're not really having an informal conversation here. We're talking about shades of distinctions, nuances. And private label in Florida beverage law basically allows for vendors of alcoholic beverage brands, that is a retailer or a liquor store owner, as an example, to create his or her or its own brand, it being the store, the entity. So let's say I own a liquor store, Jack's Liquor Store as an example, and I want to put a unique, I've come up with an opportunity for me to sell my own vodka, Jack's Vodka. Now, remember, we talk about Tide House often. Tide House precludes or prevents vendors and retailers from a crossover in ownership interest with upper tier industry members, and the converse as well. So that generally precludes vendors from being brand owners, right? A manufacturer produces a spirit, but if you qualify as a manufacturer, then you can't be a retailer or a vendor. We know this. Well, the private label exception, in fact, is again indeed an exception, and it does permit vendors of alcoholic beverages, retailers, to own their own labels, a la Jack's Vodka. But how does that relationship work, right? So generally what happens in that instance is, and let's stick to our store, Jack's Liquor Store. I don't even know if there's one in existence where I am. There may be, there probably is somewhere, I'm sure. But let's just say I want to produce my own brand, Jack's Vodka. I can actually contract with the producer to produce that product for me. He manufactures the brand, Jack's Vodka, under my label, right? It could be, in fact, reminiscent of the logo on my store or some other label I might design, but use my name. And the producer produces the product. And then, interestingly, I'm going to read this for you just so you can hear the language, okay? This is actually from Florida Code. On private label specifically, and it says this: the vendor shall not set the price of private label products with the manufacturer or distributor. Pricing shall be independently established by the manufacturer and the distributor. So it's kind of an interesting and difficult relationship for the vendor. But what's supposed to happen is this. So I am the retailer, the vendor. I go to a manufacturer to produce the brand. The manufacturer produces the brand for me. The manufacturer then sets the price and sells the brand to a distributor. And then that distributor sells the brand back to me as a vendor, and I can then sell it on my shelf. And the advantage to me clearly is that I am making my margins on sale when I sell the product at my store. If I own the trademark, I can be, in fact, the exclusive outlet for the product. That is the language of the code. So there is that requirement, again, that I do own the trademark for that. So, it contrasts quite significantly with this concept of a contract package brand, but it does provide for a unique outlet for an alcohol beverage brand for retailers. They can certainly promote the item in store. They can, make their profits on the sale of that brand. It's clearly a promotional item as well. When they sell it and it circulates in the marketplace, people will sort of see the name of the store and will act as a promotional tool as well. And the interesting thing also, though, is that the vendor has the ability, and again, this is codified in the code section, that the vendor can actually be paid royalties for the brand if they hold the trademark, and they sell that trademark off to some third party, potentially to maybe a manufacturer, as an example, or some other third party. So a royalty agreement would be put in place, or some other sort of contractual relationship, where the vendor would receive royalty payments by selling the trademark to that private label brand. So, there is, again, the distinction, and this is what I'm trying to draw here, between the concept of a contract package product and a private label brand. Again, one would qualify as an upper tier industry member, while private labels in the state of Florida are those brands which are owned by Florida retailers or licensed vendors, and then generally sold at their premises. In the realities of the marketplace really suggest that another retailer will not likely, let's say Jim's Liquors, will not really be interested in carrying Jack's vodka for obvious reasons. So you'll tend not to see that product circulated through the broad market, but almost always sold in one particular vendor's location, the owner of the brand itself, or the owner of the mark of the brand. So that's a bit of a summation of contract packaging and to a very limited degree private label, and the distinctions between the two in a general way. And both concepts obviously can be incorporated in distilled spirits, malt beverage, beer, and wine. The opportunities exist generally in all commodity types. It's a unique opportunity. Now, I obviously, for the brand owner concept, that is someone who let's pull apart or separate the vendor from this discussion and just go back to the brand ownership part again. So, the contract packaging arrangement, as I started this little podcast with, or this short podcast with, is a really great way to launch a brand. Again, it allows for the brand owner to take a lot of valuable resources and to use those funds to market, promote, and sell. I mean, that's really what gets the brand on the shelf, and that's what really gets the brand off the shelf, right? You can't just produce something and put it out there and keep your fingers crossed it's going to sell. It doesn't work that way anymore. Unless, of course, well, if you're perhaps some, fabulous celebrity that people automatically, do it, and you have some, I don't know, let's call it a podcast where you can promote your product and people automatically buy what you put out there. Well, maybe it'll work. A significant expenditure is required in terms of sales and marketing activities to be successful in this very, very highly competitive industry. Like, you walk into any liquor store, right, and peruse the shelves, walk up and down the aisles, go to the vodka section. You'll see it's filled with hundreds and hundreds of different brands. And the same is true on virtually any other category of alcoholic beverage in any store, including beers, including wine. So the landscape is competitive, and you've got to really spend that treasure in order to stand out. Again, and standing out through ads and marketing is essential. So I think pretty much we're going to wrap up this little podcast with that. I hope that it gave you some idea as to the distinctions between the two concepts. I hope maybe that it gave you an idea and inspired you perhaps to take that notion that might have been rolling around in your head, that in terms of creating an alcoholic drink, and help you figure out at least step one in how you're going to go about getting this product to market. I'm going to tell you what, if you're If you're really considering listening to the podcast, feel free to give us a call also here at Green Spoon Water and ask for me, Brad Berkman. I'll be more than happy to begin discussions with you and help you launch this brand appropriately, and in fact work with you to establish and draft and memorialize and finalize all the agreements necessary to make this happen, as well as all the licensing work. We do all of that, those types of activities here, and we enjoy it. It's kind of our passion, if you will. And for now, I'll just say thank you for joining us, and we like to close each little episode with cheers in a foreign language. Today we're going to say gunbae, which is Korean for cheers. So on that note, once again, gunbae, and thank you for joining me on the Ardent Spirit.